So the issue of New York's new concealed carry bans was once again ruled on after the Supreme Court's recent 8-1 decision and remand of that case. And now this case is likely going to head back to the Supreme Court for a new decision. Now, really quick, before we jump into this video, I want to thank one of the main supporters of this channel, which is First Form. A lot of you guys know that First Form not only has amazing supplements like whey protein, energy drinks, and all of those things that I use every single day, but also they're pro-freedom, pro-America, and they support this two-way content. And right now they're actually doing a giveaway. It's a hunting giveaway with a package that's worth about $4,500. So if you purchase products using my link down below, not only will you get entries into that giveaway, but also using my link down below to order things automatically gets you a free 4-pack of energy drinks. Now, as I mentioned in the intro, in this video, we will be discussing how this issue of concealed carry bans out of the state of New York is once again been decided on after the Supreme Court issued an 8-1 decision in the Rahimi case, and then remanded this New York concealed carry ban back down to a circuit court for a new decision in light of what they said in Rahimi. You may recall that recently the Supreme Court granted, vacated, and remanded the case called Antonyuk back down to the Second Circuit for a new decision in light of what the Supreme Court said in Rahimi. And now the Second Circuit has issued a new decision on the concealed carry bans in New York, and they have essentially reissued the same decision, finding that the Rahimi case did not change the outcome of what they said at all, and essentially they just reaffirmed what they said prior. We all anticipated that the Second Circuit would likely rule the same way that they did prior, even after the Supreme Court Rahimi decision, because it did not look like Rahimi would really change the outcome at all. But the Supreme Court decided to GVR the Antonyuk case despite all of that, and exactly what happened is what we all anticipated. The Second Circuit ruled the same way and is likely teed up this case once again to make its way to the Supreme Court. Now, this issue of concealed carry bans in New York has been a long battle and should have probably ended after Bruen, but after the Supreme Court's Bruen decision, which struck down the original May issue CCW licensing scheme out of New York, the state of New York decided to pass a new law just 8 days after Bruen. Now, this law was challenged in multiple cases, and in all those cases, some of them were issued preliminary injunctions, essentially halting temporarily some aspects of the CCIA. However, the state of New York then appealed those decisions up to the Second Circuit, who then granted blanket stays on all those decisions. And that led for the first time for organizations like GOA in the Antonyuk case to go to the Supreme Court on an emergency basis. Now, at that time, the Supreme Court did not want to get involved, so they decided to not agree and grant those emergency applications. But there was a warning issued by Alito in those denials saying that the Second Circuit could not just issue blanket stays. They would need to address all these cases as fast as possible. So the Second Circuit at that time did issue expedited hearings. In response to that, the Second Circuit did rule in 5 consolidated CCIA cases, and those cases challenged various aspects of the CCIA. Some of them were specific to sensitive locations like places of worship, and then some of them were a little bit more comprehensive like the Antonyuk case. Now, in reaching their decision, the Second Circuit agreed with the state of New York, and they found that Bruen was an exceptional case, and therefore the Second Circuit decided to vacate much of the district court's preliminary injunctions, finding that virtually all of the CCIA was facially constitutional under the Second Amendment and also under Bruen. Now, in response to that Second Circuit ruling, GOA then filed a second petition for emergency Supreme Court intervention. Although this case was still in an interlocutory middle aspect of the case, the Supreme Court did decide to GVR this case in light of their 8-1 decision in Rahimi. What that means is they decided to grant, vacate, and remand the prior decision of the Second Circuit. They decided to send that back down the Second Circuit for a new decision in light of the analysis that they had in Rahimi. Now, you may recall in Rahimi, the majority of the court in an 8-1 decision found that the domestic violence restraining order laws, the federal laws, that those did not violate the Second Amendment because there were traditions and principles that pointed to the constitutionality of that law. Now, at that time, a lot of us were scratching our head about that because there was nothing really in Rahimi that we thought would really change the outcome in the Second Circuit Antonyuk case. It really would change any of this. But at that time, I think the Supreme Court just did not want to get involved. So they punted this issue back down to the Second Circuit, hoping to buy some time and eventually probably knowing that at some point this would make its way back to them. And now you have the Second Circuit that has ruled in Antonyuk, and lo and behold, they found that Rahimi did not change the analysis really at all, and they have reinstated and pretty much reissued the same decision. Now, in this decision from the Second Circuit, they state, having reconsidered the prior decision in light of Rahimi and the parties' supplemental briefing regarding the effect of that decision on our reasoning in this case, we now issue a revised opinion in Antonyuk. We reach the same conclusion that we reached in our prior consolidated opinion. Accordingly, we affirm the district court's injunction in part, vacate it in part, and remand the case back down to the district court for further considerations in light of our amended opinion. So what the Second Circuit is saying is that they're issuing pretty much the same decision despite there being a new 246-page opinion. They're pretty much doing the same thing. There was some additional language in there that was positive, but for the most part, the Second Circuit did exactly what we thought. Now, also in the decision, they state that as further detailed below, Rahimi involved a regulation of firearms that is quite different from any of those at issue in the present case, and thus has little direct bearing on our conclusion. Specifically, the complaint before us does not challenge a criminal prohibition of firearms possession by a particular class of individuals based on a prior judicial adjudication. Instead, it concerns facial challenges, not all of which are rooted solely in the Second Amendment to a shall issue licensing regime for firearms possession and to restrictions on firearms possession in certain sensitive locations. The court addressed neither issue in Rahimi. So here the Second Circuit is saying, we're not really sure how Rahimi really is impacting the outcome of this case at all, because we found some of the things in Rahimi that were addressed by the Supreme Court really are not similar in this case at all. They want to say that in any event, they have decided to follow the Supreme Court's mandate, which they have to do, and they have reconsidered all of the conclusions in light of Rahimi. And after receiving supplemental briefing from the parties on that decision, they are pretty much coming to the same conclusion. Now, one important thing that did come out of this decision and one new development was the fact that the Second Circuit actually said that they disagree with what the Ninth Circuit ruled in a different case dealing with a similar concealed carry ban, and that was the Wolford case. That is the Hawaii concealed carry decision that was recently issued by the Ninth Circuit, along with some of the other California SB2 lawsuits. You might remember that in the Wolford Ninth Circuit case, the Ninth Circuit found that the public carry ban in Hawaii was okay, essentially, because the state of Hawaii and the statute there had various ways that an individual could receive notice that carry was allowed on private property that was open to the public. They could either have a sign that said, yes, you can still carry here, or the business owner could verbally tell everyone or have some other broader notice that was issued. The Ninth Circuit found that that made that issue a lot different from California's SB2 law. And so essentially the Ninth Circuit upheld the statute there in Hawaii, found that it was constitutional because it had these other ways that you could get notice. Now here in the Antonyuk case, the Second Circuit disagrees with that analysis that was performed in the Ninth Circuit. And the Second Circuit found that the outright carry ban is in fact a violation of the Second Amendment, despite all these other notice aspects that might be applied. They found that there is no text, history, and tradition to support an outright carry ban like that, where you would need to get permission to carry concealed at that location, even with a permit. And now this is also very important because this is now opening up a very interesting circuit split between the Ninth Circuit, a very left-leaning progressive circuit court, and the Second Circuit, which is also a very left-leaning progressive circuit court. But in these decisions dealing with the same issue, the same catch-all vampire rule, you have two different conclusions. The Ninth Circuit found that in some aspects it could be upheld. And then you have here in the Second Circuit, they're saying that no, it cannot, pretty much under any circumstance. So that's very important, and it's going to tee up some further issues going forward on review potentially to the Supreme Court. Now, what does this really do? Again, it just reaffirms the prior Second Circuit decision and is now teeing this case to go back to the Supreme Court likely very soon. There's probably going to be a petition for reconsideration. This will still be interlocutory. It's still going to be a preliminary injunction. So one of the things that could happen is maybe you would have the parties here, the Antonyuk plaintiffs, which is run by GOA. They could decide maybe to just take this back down to the lower court and try to get a final merits decision, but you have some other final merits decisions that have been issued out of the Second Circuit. So this is something that's probably going to get to the Supreme Court very soon once again. And the Supreme Court tried their best to kick the can down the road. We all kind of knew what they were doing. We didn't really think that the Rahimi decision was going to impact the outcome of the Antonyuk case at all. We didn't think that it would change it really at all. And that's exactly what happened. So that's where the New York concealed carry ban case currently stands. That's what just happened. And now this is likely going to make its way back to the Supreme Court. So if we get any more information, if anything else develops, I will let you guys know. Also, if you like this video and you'd like to support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm, and it signals to YouTube that you guys see value in these videos and in this type of two-way news. But as always, thank you all for watching. Don't forget to like and subscribe. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.